Does a person have the right to be in a public area, filming a public event as part of their job, in exercise of their First Amendment rights to freedom of the press? Or does a mob of thugs with masks over their faces and sticks in hand have the right to use physical force and intimidation tactics to prevent a person from engaging in their First Amendment rights to freedom of the press? My name is Michael Strickland, and on the evening of July 7th, 2016, I was out filming a protest as part of my job in exercise of my First Amendment rights to freedom of the press when I found myself being attacked by a mob of thugs with masks over their faces, sticks in hand, led by a guy by the name of Benjamin Carenza, who is literally twice my size. He weighs 400 pounds and he has a very lengthy criminal history. And these people put me into a position where I had to act in self-defense to prevent them from beating and robbing me. I was the one found guilty of multiple crimes, 21 counts total, 10 of which are felonies of unlawful use of a weapon, all for not wanting to be beaten and robbed. Meanwhile, the violent thugs who started the fight are considered to be the innocent victims. Now, I know a lot of you watching this have been paying attention to the case. If you're new to the case, I'm going to save the gritty details from this video. There's plenty of other videos here on my channel where I go into that, including analysis of all the different video angles of what had happened. But I wanted to bring everybody up to speed as to where we are in the case. So the evening in question was July 7th, 2016. And the trial ended up being in February of 2017, so that's what, about 8 months later, 7 months later. Judge Thomas Ryan found me guilty of 21 counts, and in doing so, by claiming that my actions were unlawful, he is by default saying that the mob of thugs who attacked me, that their behavior was lawful, legal, and to me, that essentially legalizes mob violence in the streets by saying that those actions are completely legal, completely acceptable, completely lawful. So, of course, I'm appealing the case because my actions were solely in self-defense. In fact, I'm still waiting for somebody to explain what somebody is supposed to do when they're attacked by a mob of thugs in the streets. If my actions were unlawful, what is someone supposed to do? No one's explained that yet. Not the judge, not the prosecutors, not any of the ambush witness police officers. None of these people have explained what somebody should do in the situation that I was in. So in May of 2017, we had the sentencing. I believe it was May 3rd. I'll get into that into a different video. But later in May, we had filed our formal notice of appeal. And then that gets the whole process rolling, which in itself is a long and arduous process. So a few weeks later, in June now of 2017, is when the transcripts were ordered. Now, the way the appeals court works is everything is done off of the transcripts. The official typed out written record of what had happened, what people were saying throughout all of the hearings, proceedings, the trial, all these other things. So that is the official record that the appeals court goes off of. Now, the appeals court does not necessarily, we're not there to re-argue the case. We're not going over the evidence, really. We're not necessarily, making arguments as to why I'm innocent because citing self-defense statutes and whatnot. What we're doing in the appeals court is we are citing errors that were done during the trial court level, things that the judge admitted into evidence that we feel he should not have admitted, and things that the judge ruled to be inadmissible that we felt should have been admissible, along with some other little shenanigans that have gone on. So that's what we do in the appeals court. And then we bring up case law precedents that support the things that we are bringing up. So June of 2017 was when the transcripts were ordered. And it took them 4 months to get us the transcripts. And my appeals attorneys say that that's the longest that they've ever seen it take to get transcripts. The attorney that I have now working on the appeal is Robert Barnes out of LA. He's a sort of an attorney to the stars of sorts. He's handled several high-profile cases. He occasionally appears on national news stations to give legal analysis of certain things. So while we were waiting for these transcripts, they kept delaying it. They kept they kept motioning for extensions of time to do the transcripts. So come October of 2017, we finally got the transcripts. By the way, as I'm doing this video, it is late November of 2018, so this is over a year now from the time we got the transcripts. So then we are now on the clock. We have 15 days to agree with the transcripts, and then from there we have 45 days to put together our initial written brief to the appellate court. And so that put us out to mid-December of 2017 at that point. So, after several emails and phone calls back and forth with the attorneys, we submitted our written briefs to the appeals court in December of 2017, right in line with the timing. So now the state is on the clock to submit their response to our written appeal. So come late January, when they were due, that's when this gal, Susan G. Howe, who has been featured in some recent videos here on Laughing at Liberals for her other shenanigans and whatnot, she files a motion to the appeals court saying that she needs 131 more days to file her initial brief. She's asking for an extension of what was originally 45 days. She now wants an extra 131 days to file this thing, which we felt was pretty odd. And there again, I have a whole nother video that goes into that. So now come June of 2018 is when she's due to file her response to our written brief. So she filed that in June, along with a motion to exceed the word limit by 2,000 words, because the appeals court has a 10,000 word limit in the documents that you send them. So she couldn't fit her brief within that 10,000 word thing, so she filed for an additional 2,000 words. And so realizing now that the courts are playing it sort of fast and loose with their own rules, we also motioned to exceed the word limit by 2,000 words. And we used that opportunity to rebut some of the things that Susan G. Howe was mentioning in her written thing there. So now, come October 12th of 2018, is now when we get our opportunity to go before the appeals court and do the oral arguments, where we get to appear in person and state our case. And basically, again, we're citing all sorts of case laws that support everything that we're saying. So, again, in the appeals process here, we are we're citing things that the trial court erred on. They're called assignments of error. And we brought up 6 of those that had happened during the trial and the other proceedings. And that starts with the change of venue motion that was denied. We motioned for a change of venue, which is essentially to bring the trial to a different jurisdiction in a different county, because we felt that there was defamatory and untrue statements going around about me in the local media that have been propagated by the district attorneys themselves. When I had shown up for my arraignment, and I have another video here on the channel that goes into a bit of this particular thing here, but when I had shown up for my arraignment the day after the incident in question, District Attorney Kate Molina then pulled out this phony police report that I didn't even know existed by this guy I hardly even know, who's making all these claims that I'm threatening people, and that I have ties to these white supremacist groups, that I'm sending this guy threatening race-based text messages and voicemails. It's completely untrue. I don't do that sort of thing. But the district attorney is using this police report is citing these things in front of the media as TV cameras are rolling, and as reporters from OPB and the Oregonian and other outlets are openly recording what she's saying, and then they're publishing all of this stuff. It's completely untrue, completely made up. Again, I have another video that goes into more details on that. So because that stuff is being propagated by the media, we knew that I was not going to get a fair trial. And sure enough, when the trial was starting, and we do what's called voir dire, where we're asking questions of the jurors. Of course, everybody had already heard about the case. Everybody had already made up their mind about the case. There were people in the crowd who had known of me for several years, one of which is a volunteer for Ceasefire Oregon, which is an anti-gun organization that I have done several video pieces and blog pieces about over the years. So she already knew who I was. She already had a negative perception of who I am and what I do. There were other people in the juror pool who, if I recall, were actually at the protest in question on July 7th, 2016. There were other people who had been to other protests that I had been at and filmed and posted things up. So we had all these people who had already made up their minds about the case, which we knew was going to happen, and we were denied our change of venue motion, which forced us to then do what's called a bench trial, where we then rely on the judge to be the finder of fact, as it's called. So that's our first assignment of error. Our second one is the judge ruled that it was inadmissible to present anything regarding my physical condition and my mindset regarding a prior incident that had happened to me 16 months before this. And that's going to be coming up in a future video here. But in March of 2015, I had 2 video cameras stolen from me, and I was body slammed onto the pavement, fracturing my arm in multiple different places, requiring multiple surgeries. I have a piece of metal in my arm holding me together with 13 screws going through my bones, through my humerus bone, holding me together. So that, of course, plays into someone's mindset when they're now being faced with a mob of thugs who are very aggressive, who are physically attacking them in the streets. The judge ruled that that is inadmissible. And we're stating the case, of course, that goes into my physical ability to defend myself and my mindset, having personally been attacked and robbed in the past. Of course, that plays into my mindset as it's about to happen again, and of course is more credence for me to act in self-defense to prevent a repeat of that happening again. The judge ruled that that's inadmissible, completely irrelevant to someone's mindset in the situation that I found myself in. So our third thing here is the statements that I made to the detective while I was in custody on the evening in question. Now, usually it's the defense that wants those questions tossed, not admissible, but in our case, we wanted those to be admitted. Because, again, I was basically telling the detective what had happened. I'm standing there minding my own business. I'm attacked by these guys with masks over their faces and sticks in hand. They're carrying their anarchist flagstaffs, which I've personally seen used as weapons. I know that these people have oftentimes affixed little spikes to the bottom of these things, which help them to smash windows and smash other things better. I've seen these things with little lead weights affixed to the bottom of these things. I've personally seen these anarchist flagstaffs used as weapons. So everything that I told to the detective when I was in custody, we wanted admitted, because that, of course, plays into my mindset of what I was thinking at the time when I acted in self-defense. The prosecution, Kate Molina and Todd Jackson, another one of the prosecutors, were arguing that that is not admissible, that it's some sort of hearsay thing, which is odd because they argue in other cases that statements to detectives should be admitted into the evidence. So we're bringing up all sorts of case law examples that play into our argument for that those statements should be admissible. But the judge ruled that those statements are not admissible. So that was another one of our errors that we brought up. We also brought up that that Kate Molina and Todd Jackson refused to clarify which part of the laws that they were charging me with. Now, unlawful use of a weapon was the 10 felonies, and that actually has 2 separate definitions, and both of those actually have sort of sub-definitions as well in the Oregon laws. And we motioned for Kate and Todd to clarify exactly which parts of the law that they were charging me with. They refused to do so, and the judge agreed with Kate and Todd, saying that they don't have to clarify which part of the law that they're charging me with. Which of course we argue that they need to do that in order for us to come up with a proper defense against such. So my right to know that stuff was denied. And so that is another one of our assignments of error. Another one is the ambush witness, and I've gone into a little bit of that here on the channel, but this is probably the most complex one out of all of these things. So as the trial went on, the state brings up their case. They call it the case in chief, I believe, where they're bringing up their witnesses. They're, analyzing the videos and bringing up things that why they think that I'm guilty. When the videos show that these mob of thugs were planning and orchestrating their attack and then carrying it out, and how they were threatening and menacing. So they had plenty of time to bring up an expert witness. Now, an expert witness is not necessarily someone who was a direct witness who saw what had happened, but they're somebody who is an expert on the topics at hand who can testify to bring some more clarity as to, the situation in question. Now, Kate and Todd had known for at least a month and a half, maybe longer than that. I'm sure, I don't remember the exact details, but they had known for quite a while that we intended to bring up an expert witness who was a former instructor of police officers in firearms use, use of force, and tactical training. We intended to bring him up. And we did during our part, but the state here, Kate Molina and Todd Jackson, they did not put forward an expert witness during their case in chief, even though there were several Portland police officers who testified during the trial who could have acted as their expert witnesses because they have similar experience and similar training. So we bring up our witnesses, we state our case during now our case in chief, where we go on after the prosecutors. And then after we rest, so the prosecution had rested and we had rested, that's when Kate and Todd decide that they want a motion to bring up their own expert witness. And we're sitting there going, wait a minute, you've had a month and a half to arrange for this. You knew we were going to be bringing our own expert witness up. You had several Portland police officers that could have testified to this sort of thing. You chose not to do any of those things. And now, after you've rested, you're wanting to bring up an ambush witness on us? Now, Oregon evidentiary laws specifically state that both sides are supposed to keep the other side abreast as to the witnesses that they are going to be calling forth. And this guy who they ended up bringing up, Officer Ryan Rasmussen, the judge agreed with the prosecution in this, that it was now appropriate for them to bring up their own ambush witness that we didn't even know about after both sides had rested. And Todd Jackson was making the case that our expert witness was testifying to things that Todd himself was not prepared to address, which is a little odd because during the pre-trial hearings, when we were talking about this, Kate and Todd actually wanted our expert witness to be stricken completely. They were motioning for him to not be able to testify. But we ended up clarifying exactly what our guy was going to be testifying to, and that is, basic firearms usage, use of force tactics, and specifically to my actions, which is exactly what our expert witness had testified to during the trial. So now Todd is claiming that our guy was testifying to things that he wasn't prepared for? So the judge allowed Kate and Todd to bring forth this ambush witness on us. Ryan Rasmussen is his name, and I've already gone into one or two videos here on the channel. I'm going to be getting into another episode here regarding this guy. Ryan Rasmussen is his name. He's the firearms instructor and use of force trainer for Gresham Police Department. What's interesting is that he only has experience in firearms as military or police. He has no experience as a civilian because he went straight from the Marines, did a short stint as official armed security, and then was hired on by Gresham Police Department. So he has zero training as to what it's like being a civilian. In fact, he has no qualifications to instruct civilians. And he admitted on the stand that his testimony is only in regards to what a police officer is trained to do, and that police officers are held to a higher standard than what civilians are. So the judge allowed all of his testimony to be admitted onto the record. So that's another one of our appeals things, is because we feel that he was an ambush witness, and his entire testimony is irrelevant to my case because he could only testify as to what police officers are trained to do and not do. I'll be getting into that in a future episode here. So our last assignment of error are the First Amendment restrictions on me. And I'll be getting into that in another episode as well. But as it stands right now, I am legally banned by the judge as part of my sentencing. I am banned from filming protests, filming anything at Portland State University or Portland Community College, banned from filming anywhere where I'm told to leave, and I cannot film anybody who tells me to not film them. And we, of course, feel that this is a gross infringement on my First Amendment rights. Why the ACLU has stayed mum about this, I don't know, because if they can do this to me, then they can do this to anyone. Scarier yet is that my First Amendment was actually further restricted, and again, I'll be going into this into a future video. It was further restricted under different circumstances, but I'll get into that in a later thing. So we had our in-person hearing, our oral arguments in front of the appeals court on October 12th of this year, 2018. And from what I understand, it takes the appeals court anywhere from a month to 6 months, or even more, to issue their ruling. What's scary here, again, like I said, if my actions were ruled to be unlawful, then that means self-defense was not warranted, which by default means that the actions of Benjamin Carenza and the rest of these violent mob guys are considered lawful, and that puts everybody at risk. Those who have been paying attention to the case and paying attention to some of the things that I've said or written on Twitter may have seen me use the term dangerous precedent or scary precedent. That's exactly what's been said here. Mob violence has been legalized in the streets. It's now legal for a mob of thugs to attack not only journalists, but anybody in the streets. And I'm hopeful that the appeals court will recognize that a person, me, has a First Amendment right to be there, and that Benjamin Carenza and his mob of thugs do not have the right to use physical force and intimidation to prevent me from engaging in my First Amendment rights. So the appeals court can do a variety of different things here. Best case scenario is that they can overturn the entire thing and do what's called vacate the conviction. And if they do that, then illegally, it's as if this entire case never happened. I get my life back, I get my freedoms back, and I can finally start moving on in life about these things. So the second best thing that the appeals court can do is what's called remand it to another trial. And that's where they look at everything that we brought up and they say, okay, yeah, this guy didn't get a fair trial. He gets another trial, and hopefully that would come with some specific instructions, namely the change of venue thing, that motion that we were denied. The judge had denied us change of venue, so the appeals court can rule that. The appeals court can also overturn certain portions of the sentencing. In this case, the First Amendment restrictions that have been placed on me. The appeals court can say, yeah, that is a violation of his First Amendment rights. You can't do that. That's not within the scope of what a judge can do in the sentencing. So then I would get at least my First Amendment rights back in that case. Now, the appeals court can also, getting into the negative side of things, the appeals court can also affirm the lower court's ruling. And that is where the appeals court judges agree with everything that was done in the appeals court. That they'll agree that a judge can place these First Amendment restrictions on me, that the state can present ambush witnesses, that the state is not required to clarify which part of the law that they're charging somebody with, that prosecutors can make defamatory statements and untrue statements about someone in front of media, all those other things. But the premise of it is the appeals court would basically be saying that, yes, we agree that mob violence is legal on the streets and you can attack anybody and get away with it. So, again, I'm hopeful that the appeals court will overturn this, or at the very least remand this back to another trial. But if the appeals court rules that a mob of masked thugs have the right to physically attack people on the streets and prevent people from engaging in First Amendment rights, then I will have to appeal this up to the next level, and that is the state Supreme Court. Now, in my studying of all these different things, because I've been researching a bunch of case laws and how all these things work, the appeals court is actually more likely to affirm a lower court's ruling, and the state Supreme Court is actually more likely to overturn it. So that's my next step in this. Again, we're waiting for the appeals court to rule. I'm very hopeful that they will rule in favor, to me, at least on some degree. But if they don't, even if they only overturn the First Amendment restrictions, I still intend on taking this up to the next level, which would be the state Supreme Court. So we go through all this rigmarole again. This lasts another year or so. It's already been coming up on 2.5 years since the incident in question. So I'll have to take it to the Supreme Court then. And if the state Supreme Court upholds that mob violence is legal on the streets and that the First Amendment is invalid, then I'll have to take it to the federal Ninth Circuit Court. Now, we've heard a lot of crazy things about the federal Ninth Circuit Court, but one of the interesting things that I've discovered is right now that there are 6 vacancies on the Ninth Circuit out of 20 some odd judges, and President Trump gets to fill those 6 positions. But then if the Ninth Circuit affirms the ruling, and they agree that it's legal for a mob of thugs to attack journalists in the streets, then I'll be taking it to the Supreme Court of the United States. This whole thing could still go on for another 5+ years. I have no intention of giving up this fight until at some point, somewhere, at whatever stage I need to take it to, a court overturns this thing and realizes that a mob of masked thugs do not have the right to attack journalists in the streets. And if they do, the journalist has a right to defend themselves against such. Thank you for watching. I think this is my very first-person video here on my channel here. I plan on making more of these in the very short future, going over the case and some other things. Again, if you're new to this case, I implore you to watch some of the other videos here on my channel that go into the nitty-gritty details. But until next time, thank you for watching.